it appears a process is underway that could cancel the election for District Attorney of Georgia's Western Judicial Circuit and delay it for up to 2 years. Thanks to an obscure law passed in 2018, the choice whether to suppress the votes of over 150,000 people in Athens-Clarke and Oconee counties is now in Governor Brian Kemp's hands.
Hi, my name is Adam Shirley. I'm an 8th grade science teacher. I think the right to vote is one of the most fundamental rights guaranteed to all us Americans. That's why I'm suing Governor Brian Kemp, alongside Deborah Gonzalez and 3 other residents of Athens-Clarke and Oconee counties.
I was so angry when I first heard that my ability to vote in this election was taken away from me. It matters to me. And I don't care who it is that you're voting for, whether or not you're voting for a Republican, a Democrat, or an independent. Everybody deserves the right to have their vote.
It shouldn't be up to the governor if a county gets an election. That should just happen.
You can't just take away the people's ability to go to the poll and select the DA that they want. That's basic. What we're saying is basic democracy.
The problem started in 2018 when the Georgia legislature passed HB 907 specifically to disenfranchise the people of Douglas County and prevent Dahlia Racine, a woman of color, from becoming DA there. Now, this unconstitutional law is being used again, this time against us. When Ken Malden resigned as DA after almost 20 years of service, Governor Kemp didn't have to do much to suppress tens of thousands of votes in Athens and Oconee. In fact, he did nothing. And by doing nothing, and failing to appoint a replacement for Malden before May the 3rd, the entire DA election was canceled.
This is an attack on the voting rights of all of us. I felt that we had to stand up and reclaim our right to vote. That's why I joined Deborah Gonzalez as a plaintiff in Gonzalez v. Kemp. Together, we're fighting back to restore our rights and the rights of over 150,000 other people in Athens-Clarke and Oconee. But what does a lawsuit like this involve? What are the next steps? Step 1 was to file the case in federal court and submit a motion for a preliminary injunction to have the election placed back on the ballot.
A hearing was held in front of Judge Mark Cohen on June 25th over Zoom. We made 3 arguments in this hearing. First, that voters of Athens and Oconee have a fundamental right to vote, protected in the First and 14th Amendments to the U.S. Constitution. Second, if Kemp is allowed to cancel an election, he might choose to do that based on the political affiliation of voters in the district or ideas expressed by the candidates. That's a second violation of the First Amendment. And finally, HB 907 violates the Georgia Constitution, which states an election for DA will be held every 4 years.
You know what? We won.
I'm so proud of you.
We did it together. A group effort, you know?
But we were just getting started. The governor asked Judge Cohen for a stay of the motion. In other words, cancel the election again, claiming that if voters were allowed to cast their ballots for DA, that it would cause harm to the state. Judge Cohen disagreed and denied Kemp's motion for a stay.
I have to say I was elated. I was so excited and joyous and happy because I felt like the Constitution won. The fact that we have a right to vote in the election, that's a win.
But Kemp kept trying to take away our right to choose our own DA. He appealed to the 11th Circuit Court, asking them to stay the motion. They did not. So again, we won, and the election stayed on the ballot for November.
It felt good. I felt that maybe the little people will win. Or maybe someone that's representing the little people wins, you know.
The 11th Circuit did, however, certify the question of constitutionality of HB 907 to the Georgia Supreme Court, the authority on the Georgia Constitution.
So that's our next step, a hearing at the Supreme Court on Tuesday, September 15th. And we're going to win again.
Anytime somebody's right to vote is suppressed, we all need to collectively work together to stop that from happening. It's our job. As patriotic Americans, we've got to stand up to that, and we've got to make changes.
Hi, everybody. I know usually I just have the coffee with Deborah, but I just got the most amazing news, and I just need to share it with you. We won! We won! The Georgia Supreme Court gave a unanimous decision that the 2018 law is unconstitutional. What does that mean? It means that that law is now stripped. Thank you guys for your support. Thank you for being with us in this fight. The people did it. We got our election back. I am honored and humbled to serve as your next DA. And I am so proud to be the first woman and first minority DA in this circuit, the first Latina DA in the state of Georgia, and the first female Puerto Rican DA in the entire country. We have made history together. Justice was on the ballot. Now justice is on the agenda. Thank you.